All right, let me get my. Hey, you have one job.
Oh yeah.
We're getting our board turned on right now. We can't see you yet, so.
Okay.
We'll get that here.
What's with that?
Please,
Thank you.
is it plugged in even?
You had one job.
Yeah, somebody in one of my classes. This class?
It was AJ and Andrew.
Was it really?
Yeah. I think that's what Cody just said.
I did not say that.
It looked like somebody threw something and splashed wax all over the wall.
It definitely wasn't that.
Yeah. Okay. Let's hold on a second. Get you connected here. Oh, now I lost you again. Okay, we can see you. Now I just got to get us on here. Okay. Okay. Now I think we got everything going. All right, welcome. How are you today?
I'm well, how are you?
So good. Students, this is Kim Bowman, Jr.
Hi.
This is our class.
Hello.
All right. Well, everybody's ready. We can take some notes. We'll have some questions for you here towards the end. But I'm going to let you start. Tell this class what you do and why you're our guest today, I guess.
Okay. So I am an attorney by training, and I am both an attorney and I am also in management in the healthcare system at the University of Utah. So as a high school student, I was actually on the debate team. I was the president of the debate team, and the research skills, the public speaking skills were very helpful. I'll just give you a quick background. I went to the University of Utah for my undergraduate education. I got a couple of undergraduate degrees. I went and got my MBA at Westminster, my law degree at the University of the Pacific in California, and a master's degree in gerontology at USC. And so all of that came together. I spent a couple of years in private practice as an attorney, and then I moved to the University of Utah, where I did contracts and legal work for the health research infrastructure. And when the University of Utah started a new department in the healthcare system dedicated to research, that was an opportunity for me to step into a management role, and now I manage the Department of Population Health Sciences for the university and the Division of Health System Innovation and Research underneath it. So I'm still practicing as a judge advocate for the U.S. Air Force Reserve, a JAG officer, a lawyer for the Air Force Reserve. And so in a couple of different ways, the public speaking has been important, obviously, through my education. You don't do an MBA without learning how to do group projects and work with other people and be able to give presentations. In business contexts, that's a very common thing, to have to get up in front of a room of people and explain a project or pitch an idea. Law, obviously, even in law school, it's common for you to have to develop those skills. A lot of law is writing, but it's an important skill set, and it's one that's developed because even if you don't think I'm going to be a trial lawyer, I'm going to get up in front of juries and I'm going to be arguing in front of judges, you still will have to at some point. Almost guarantee you're going to argue at least one motion in front of a judge, and knowing how to do that is important. But even in your writing, if you're going to be a writer, the ability to speak publicly is important, because how you write should mirror how you speak in a lot of ways. You're looking to communicate ideas, and very commonly after you've written something, what you're told to do is take that paper and read it out loud to see, does this sound right? And that's the same way that I come at writing from the front of it. I say, how would I say this? And that's how I write it. And then I read it back to myself and say, does that still sound right? So in the various roles I've taken on, be it in the courtroom or the ability to speak confidently in a small group, the ability to write convincingly, or in a management capacity, the ability to handle groups of people who report to me, or to handle large projects that we do here at the university in the health sciences. That same skill set is used over and over again.
I don't know if that was your computer or mine.
That was me, I think. I think I'm being reminded of something or other. So.
Cool. Okay, so in your positions, both in law as well as management, what would you say are the 3 most vital speaking skills that students today should be acquiring?
So I'll start with kind of an obvious one. About 70% of our communication is not what we say, or necessarily even how we say it, but how we look when we're saying it. So good form. It's not just posture, right? That would be a little obvious. It's deliberate movement. So when we're in law school, I'll show you the way we're taught to hold our hands. I don't know if you can see this that well, but the way we're taught to hold our hands when we're talking to a judge or a jury, it would be bad if you just sort of pace around, flailing your arms around, and you don't want to look like a marionette. You're taught that there's an invisible box, kind of like in baseball, that there's the pitching box, and it goes from, it's very similar for your hand gestures. We're taught to keep our hands right about here. Instead of locking your hands, you don't do the Mr. Burns, excellent, this is bad, you don't want to look like a mechanical or a maniacal genius, right? You don't interlock your fingers because it makes it hard to use them. What you want to do is place your hands web over web on your belly button. Just your thumbs resting about where your belly button is. And from here, when I'm standing up and I'm talking, I can gesture, right? I can move around, and it doesn't prevent me from walking. It doesn't prevent me from having a conversation with someone. But it means that from here, my hands, I'm only using them when I want to use them. Have you ever met someone who, when they talk, they really are hands out. They're moving a lot, right? They're really animated. They probably need to stop drinking coffee, and that's bad, because if 70% of our communication is how we look when we're talking, it's important that we be deliberate in that. The same way it's important when you choose words, you've got to choose the way you say those words. So what we say is about 10% of communication, right? Using the right word is 10% of conversation. How we say it is about 20%. Right? If I yell it, that means something different than if I speak it nicely. If I raise the end of the sentence, it sounds like a question, but if I don't, it might be a pointed argument. And then the 70% of how we look. So if I put those all together and I'm properly formed, I've got my box. I'm not going to put my arms way out here. I'm just going to gently gesture as necessary. And I'm going to use the appropriate tone. If I'm hearing what you're saying right, Your Honor, this is the question you're asking me. I'll get a question. Does res judicata apply here? No, Your Honor, and here's why. Right? So I'm gesturing appropriately. I'm using the right tone. And if I'm asking a question, I'm going to do it differently than if I'm making a point. That's the first thing, is how you look and that kind of body language. The second skill set that I'm going to say, and these kind of build on each other. You've got to get your form down properly. You want to get those things down properly. Second thing, how to answer a question. If you're public speaking, it's pretty rare that you're just going to be talking at people, right? Even here, you're going to be asking me questions later. So the theory is that that first thing I showed you should make you a better presenter. If you're giving a PowerPoint presentation, if you're talking, I teach classes here at the university, and if I'm giving a lecture, those are good skill sets. Don't just be monotone, right? Don't stand at a podium and be monotone. Move around. Use deliberate movement. Use your hands. Talk. That's good. But when you're answering a question, the second skill set you need is the right way to do it. Have you ever heard someone, especially in a lecture situation, you'll ask them a question, and unless it's a very specific question, right? If you say, when was the battle of such and such fought, that's a pretty specific answer, right? They're just going to say 1812. But if you ask them a more general question, they have a tendency to ramble on and on and on and on, and they may or may not answer your question. And then they may or may not, especially if it's a yes or no question, they may or may not even give you a yes or no. My recommendation is always answer the question first. Mr. Bowman, does res judicata apply? Instead of saying, well, Your Honor, he was hit by a bus, and then this happened, and then that happened, and then that happened, I guess maybe. The answer is, does res judicata apply? No, Your Honor, and here's why. Because he was hit by a bus, because of this, because of that. When you're public speaking, not only should you control your form, but you should pick the way in which you answer the question. If you're asked, start with a yes, a no, or you can say maybe. You can even say maybe. But answer the question, then explain it. Third thing, improvisation. You're almost never going to be able to completely plan a speech. Even if you're using PowerPoint slides, it's almost impossible to get away with 100% pre-scripted discussion. So don't try. If you're writing a speech, my recommendation is don't sit there and write 4 pages of speech, get up and then read the 4 pages of speech to podium. Those are uninteresting, and if you're going to do that, don't read it to me. Just send it to me in an email and I'll read it myself. I promise I'm going to like that a lot better than watching you at a podium read it for 5 minutes or 10 minutes or 20 minutes, or depends on how long you talk, right? Instead, my recommendation is, and if you want to long format write something out, that's fine if that's your process, just don't take it to the podium. Break it down. Break that down into a couple of key points, and you should know enough about the thing you're talking about that you don't need to write it all out. You should be able to say, look, my format is I've got 3 points I'm going to make. I'll say some introductory remarks. I'll say here are my 3 points, point 1, point 2, point 3. I'll say what I've got to say about them. I'll tell you that I just told you those 3 points, why it mattered, and I'm done. That could fit on a 3x5 card with just my opening joke is about a badger, and I'll just write the word badger. My opening joke's about a badger, and I should remember that joke. Point 1, point 2, point 3, and then my closing remark. That's it. So improvisation doesn't mean you just get up there and wing it. It means that you've put deliberate thought into what you're doing and how you're doing it, such that you're prepared when you get up there to improvise. And that means that you can be funny, and you should be funny, right? It's very rare that you can prescript everything that's going to happen. So you've got to be prepared to interact with the audience and make things up as you go.
Teachers, pardon the interruption. At this time, please release sophomore students J through L to Tiger Arena.
All right, I've got to go. I'm a sophomore student.
So now turning that around, what would you say are 3 of the most common mistakes or problems that you see novice speakers or communication skills that are failing?
Sure. So it's some antithesis of the things we've talked about, right? So poor nonverbal communication or poor verbal communication in terms of either standing improperly, pacing around a lot and looking nervous, not choosing the right words or not choosing the correct tone in speaking with them. Those are going to be the kinds of things that are most obvious. You can tell when someone's nervous, not by listening to them, but by watching them. If someone's nervous, they're jittery, they fidget, they move around too much, their motion isn't deliberate. Posture. Did I lose you? I might have lost you for a second.
No, I was saying there are a few students who fit those descriptions.
Oh, okay, all right. So here's a good example, and I don't know if you... So in the 2012 presidential election, the first debate, it was Obama-Romney, and they were standing at podiums. And just because you're standing at a podium doesn't mean that you can't do a good job about this. If you're standing at a podium, grab the sides of the podium. Don't lean on the podium. Don't be away from the podium. All you do is, it sticks out, you put your hands on each side of it, you hold onto that thing as if it's going to fly away if you don't. The only times you lift off are to make appropriate gestures, intentional gestures. Or, if the thing we practiced, the belly button thing, works just as well behind a podium. You stand behind the podium, you do this, you gesture. President Obama was seen to have lost that first debate. The general consensus of the first debate was that he lost that debate. Now, they both made prescripted policy arguments, and what they said, everyone knew what they were going to say. It's the same stuff they've been saying for a year on the campaign trail. But they looked different. Romney stood up straight. He would occasionally make notes, but he made a lot of eye contact with the camera, with the person asking a question. He was very straight. He occasionally would put his hands on the podium. President Obama, especially when they showed from behind, because sometimes you'd get a side view or a back view of the podium so you could see the person asking the question, the moderator. And what you see is President Obama was leaning on the podium, right? He was kind of leaning towards it. His feet were not firmly planted. He was one foot in front of the other, kind of bounced forward. It looked like he was going to take a jump shot, actually. He kind of had the Hornacek going on, right? That's not how we give public speeches. We're not Jeff Hornacek. This isn't a free throw. You guys might be too young for Jeff Hornacek references. Never mind. But part of the reason he was seen to have lost was simply because he looked bad. And so one of the things they corrected was in the next speech, or in the next debate, it wasn't a podium-based one. It was a floor debate, an open town hall debate, where you sat on a chair, and then when it was your turn, your microphone turned on, you stood up and you walked around. And he was seen to have won that one because his posture was better. He was gesturing appropriately. He walked around. If you're going to be giving a speech, it doesn't matter what is in front of you. And I mean a podium, no podium. A good audience, a bad audience. One person, 100 people. The same fundamentals apply. That's probably the biggest one I see is poor use of your body, right? Either too much expression or not enough. I'm clearly very scared. I don't want to be here. Some other ones that are a lack of preparation will usually show. If someone doesn't know what the heck they're talking about, you're going to know it. It's especially difficult if they're speaking to a group of experts, right? If you're talking about a law, and I guess this is a good example for law. So most of the time when you're a lawyer and you're arguing in front of people that aren't your wife, anyway, you're going to lose that one. My wife's also an attorney. There's no winning there, I suppose. But when you're arguing in a professional capacity, you're usually not doing it in front of a jury. It's a pretty rare thing to be in front of a jury. It takes a long time for civil cases. Most criminal cases settle, so you don't really, don't imagine that every day you get up and go talk to a jury. However, you do regularly speak before judges. And sometimes it's a panel of judges. And what a judge will usually do is they don't start a timer and say, you've got 5 minutes, click, go. And then at the end of the 5 minutes, they say, thank you for your speech, sit down, next person gets a speech. Judges aren't like that. Judges are the king or queen of their courtroom, and they will let you get 10 seconds. You'll say, good morning, Your Honor. I'm Kim Bowman. I represent the plaintiff. The facts in this case are not in dispute. The issue is, and then the judge is going to stop you and say, let me stop you right there, Mr. Bowman. I'm actually still interested in the facts. I want to know about what color the car was. Well, I was not going to talk about the facts at all. You just heard me say that the facts are not in contention and I don't want to talk about them. But the judge just told me, no, Mr. Bowman, tell me about the facts. So when you're dealing with especially a smart group who knows a lot about the topic, or one that is hot, we call it a hot panel, a hot group. They're not just going to sit there and passively accept whatever you say. They're going to challenge what you say or ask you questions. Preparation is the most important thing. You do not win or lose during the speech. You won or lost it in preparation for that speech. So the better prepared person is usually the winner in a debate or in a legal argument or something like that. That's 2 or 3 things depending upon how you look at it. Maybe I'll let you ask the next question.
Okay. Is there anybody in class who's ever thought about going into law? What is it about law that
Interests you? Why would you consider that job, first of all? Just because you get to argue with somebody? Okay. So, helping others. So, so do you guys, any of you that have considered, do you have a specific question that you would like to ask Mr. Bowman at this time before I ask more questions? Okay, how long does it take to become a lawyer? Like from start of school to passing the bar and getting into a practice?
Sure. So let's say you're 18, you graduate high school, and you go straight to college. If you do your 4-year degree in 4 years, then you're 22. So it's 4 years of undergraduate education. I'm now 22. Let's say your senior year of college, you study for and take the LSAT, which is the preparatory exam that is required for admission to law schools in this country. So during your senior year, probably fall of your senior year of college, 21, turning 22, you study for, you take the LSAT. It takes about 6 weeks to get the results back. You can take it more than once, so my recommendation is you take it like in the fall, and if you have to, you retake it in the spring. Nowadays, they don't penalize you for that. And so you've got your score. Now you've got your score in hand. You have a good idea of what your GPA is going to be when you graduate. So in the spring, late the November, December, January, February of your senior year of college, you apply to law school. You will find out where you've been admitted in the spring, April, May, June. You usually by July have to commit to a law school. And it's very common that you have to move to go to law school. So in my case, I moved to California so that I could attend the University of the Pacific and USC. So you move to attend law school. That's a 3-year course, usually. Now, there are some part-time programs, which are 4 years, and instead of being in school full-time, you're part-time, you can work. The American Bar Association has a rule that says that if you are a full-time law student, you're not allowed to work more than 12 or 20, you're not allowed to work more than 20 hours a week, and you can't take more than 18 credits or 16 credits, something like that. And attendance is mandatory. Your professors are required to take attendance when you go to class. It's not like a lot of college where you can go, you cannot go, whatever. In law school, you have to go. So that's 3 years of full-time during fall and spring semester. And usually in the summer, instead of going to school, you clerk or intern for a local court or a company or a law firm, someplace that you hope maybe one day to work or to try and gain experience before you go into the world. Internships are more and more important as undergraduates, but also in law school. So I was 22, I started law school. 3 years later, I'm 25, 26, depending upon when your birthday is. And then you graduate usually in May, for example. So you graduate in May, and the bar exam will be in July, usually around Pioneer Day. I think it was the day after Pioneer Day, so we had absolutely no fun and didn't get to sleep because everyone was out having a lot of fun and doing fireworks, as I recall. So between May, when you graduate, and July, when you take the bar exam, you study. That's all you do. You don't work. You don't do anything else. You study. The stack of books is at least this high, and all you do every day is go to 8 hours of lectures reminding you what you learned in law school, teaching you some stuff you didn't for some reason or another. Because in the state of Utah, for example, there are, I think, 21 subjects on the bar exam. Now, not every one of them will actually be on your exam, because the bar exam is a 2-day, all-day exam. And not every subject shows up. They're randomly assigned. So you have to learn about wills and trusts, even if you're not going to be a wills and trust lawyer, because it's one of the 21 subjects that might be on your exam. And if it's not, okay, great. You just know a thing about a thing that's important. But if it is and you didn't study for it, you just failed the bar. And the reason that matters is because the bar exam is only given twice a year. Once in the summer, once in like December, February. I think it's July and February. If you fail in July, you don't find out until September. And then you have to sign up for and take the bar in February. And you can't work for almost a year. Imagine graduating in May and not being able to go to work until February. Except that, remember, it takes 2 months. So even if you pass the bar the next time you take it, you don't find out until May. So you might actually graduate and not go to work for a full year, which is not good, obviously, because you went to law school so you could earn money, and now you've probably got student loans to pay back and that kind of thing. So figure that that the average person who goes from 18 to 22 for undergraduate to 25 or 26 for law school, passes the bar, will be about 25 or 26 if they go straight through. Most people don't do that. Most people take a couple of years between undergraduate and grad school. They work, they do something else. I think the average age of a law school graduate is 26 or 27, that ballpark.
Wow. Now, is it true that you each time with the bar exam that are they different for each state, and do you have to take a different test for each state?
Yeah, boy, that's part of the bummer. Is that there's no national test. Each state has its own test and its own set of rules. And so, for example, I'm a lawyer licensed to practice in the state of Utah. And because I am a judge advocate with the Air Force, I am licensed to practice military law in any state and in any country, right? That qualification transfers. But if I moved to California tomorrow and said, I think I'm going to move to California, I'm going to buy a house, and I'm going to be a lawyer in California, I have to restudy and retake the bar. My license does not transfer. And that means that I would have to probably take several months off because I've forgotten a bunch of it since law school. I mean, it's just like anything else. If you don't use it regularly, you forget it. And I forgot almost everything about some sections of law because I never used it. I never practiced that. So there are exceptions to this. In some cases, states will allow you, if you've been practicing 3 or 5 years, you don't have to retake the bar. So for example, I could move to Idaho tomorrow and not retake the bar, because Utah and Idaho have an agreement that says that if you've practiced for a couple of years, that you don't have to retake it. We just trust that you know what you're doing. You can move here. I think Utah has actually really good reciprocity. If you pass the bar in Utah and practice law for, I think, 3 or 5 years, depending upon the state, you can move to basically any state west of the Mississippi but Nevada and California without retaking the bar exam. And nowadays, the bar that you take in Utah automatically allows you to move to, I think, 6 or a dozen states. That's a new thing that's pretty new. But California is a great example. I went to law school in California. My law school assumed that we were going to take the bar in California, so they taught us some California-specific law. And I didn't take it there. So I had to relearn some stuff when I got to Utah. And if I ever moved back, I'd have to take it again. And if someone from California moves here, they have to take it again. And the California bar in particular is very difficult. About 50% of the people that take it fail it the first time.
Wow.
It's pretty tough. And my favorite example is there was a person who was the dean of a major law school. Let's just say it's Stanford's law school, because it was. And she left being the dean of the law school, and she was going to go be a private attorney in California. She failed the bar. So the dean of the Stanford Law School, who had been a lawyer, in New York or somewhere else before she came to Stanford, and she'd been teaching law for a number of years, she couldn't pass the bar. Probably because she just didn't try very hard.
Wow. That's crazy. All right. Okay, any other direct questions that we have? Vance.
Have you ever, felt bad after condemning someone?
Condemning? That's a...
Did I ever feel bad after what?
You feel bad after condemning someone. I think he means
condemning
after a trial situation or anything.
Gotcha. So, okay. So there's really 2 fields of law. There's civil law and there's criminal law. And you can condemn someone in both, really. The technical idea of condemning someone, I guess, is criminal, right? Crime and punishment and jail sentences and stuff. I have worked on both sides of criminal law. I have defended people who have been arrested and who were appearing before a judge for sentencing or those kinds of things. I have also worked in particular in a military context in crime and punishment. I will say this. On the prosecution side, when I was working on that side, I never saw anyone convicted who didn't do it. Who did not, who I was like, you know what, this seems like they didn't. Because the burden is so high. We don't assign a number to reasonable doubt, right? In criminal law, how guilty do you have to be? We have to know that you're guilty beyond a reasonable doubt. That's the standard. I have never seen anyone that I worked on that I felt like, man, we got that wrong, or there's a question of whether or not they did it. It was clear that they did it. It was either drug use, and the test was positive, and they were found with a bunch of drugs, and you go, well, they did it. Or there was one sex assault case in particular that I recall in the military, where this person was a non-commissioned officer, a sergeant, and they had committed crimes of a sexual nature against subordinates on 3 different continents, and for years. And when we opened up the case, a dozen people came forward and said, I wasn't going to say anything, but I heard that this person said something, and I thought I was the only one, but but I'm hearing there were all these other people. And so after a dozen people come to you and say the same thing, and none of them had met each other before, it was beyond a reasonable doubt. So in terms of that, I've never felt like anyone who didn't do it wasn't properly punished. And in some cases, I've defended people who did it, right? On defense, they did it. And so instead of arguing that they didn't do it, what we did is we worked with the prosecutor to negotiate a fair resolution that punished the person because they did it, but that didn't give them the maximum punishment. That's what I did there. Civilly is a whole different thing. If you think criminal law is tough, and the idea of sleeping at night if you put the wrong person in jail, or I have friends that are defense attorneys, and people ask them, how can you do your job? You know they're guilty. How do you defend them? And the answer is that that's how our system works, that everyone is entitled to a fair and reasonable defense, and that's how justice works in this country. But even if you're a civil attorney representing someone who was injured in a car accident, for example, if you don't, if it doesn't go well, you might have condemned them anyway, because now they don't have enough money that now that they're permanently injured, they can't live without assistance or something, right? Or if it's a family law case, keep in mind that about half of the cases filed in civil court in this country are for divorces or family matters, something related to the family, adoption, child custody. You can condemn a person if you are representing them for a divorce, because how much they get to see their kids might be the most important thing to them. But if you don't do a good job, that they may not get to see their kids as much, and that wouldn't be fair, and that could be, in a sense, condemning them. And so that is context to the larger question of how do you live with it. It's just part of the job. If you're a prosecutor, you do your very best to only do the right thing and put the bad person in jail, right? The person recognizing that people aren't necessarily inherently bad, but people make mistakes. You do your best to be fair, and that you may wake up once or twice with a nightmare that you did it wrong and you put the wrong person in jail, but you do your best not to. If you're a defense attorney, you try and give people a reasonable and fair defense. You don't necessarily represent guilty people so much as you try and help people who didn't do it prove they didn't do it, and help people who did do it get a fair punishment as opposed to just the maximum punishment. If you work in civil law, you're trying to make sure there's fair resolutions to serious, complicated problems. That's how you sleep at night, knowing that you did your best job. It goes back to that preparation thing. If you're not doing your best job, you're probably going to lose. Not only will you lose, but you will feel like you did wrong. So by being well prepared, by knowing that you read every case that mattered, by preparing your argument and delivering it the best you could, that's how you do it. Not to say that you don't Monday morning quarterback, right, and go, crap, I should have said that. That was stupid. Why did I say it this way instead of that way? Everyone does that. You're going to do that. But the way that you don't feel like like it's your fault is by preparing hard and knowing you left it all, as they would say, on the field.
Cool. So two other questions about schooling. On average, what would you say that most lawyers are majoring or minoring in their undergrad work?
This is one of those fields that you can major in almost anything. I'm at a ballet major. Went to 4 years of undergraduate education to be a ballet dancer, and then went to law school. I'd say you see a lot of people who are doing things like economics, political science, composition like English writing, people who are heavy into writing, but you'll see everything. And that's reflected in the practice. So there are some jobs, and actually a whole separate bar exam, that are specific to intellectual property issues. And in order to be eligible to sit for that bar and to practice that type of law, you have to have a hard science background. You have to have an undergraduate degree in biology, chemistry, computing, something hard science, a STEM science. And so people who do STEM degrees will often go to law school because the ability to have an understanding of the legal and the complicated regulatory side of biology and of biomedical things and of the chemical patent process, that's stuff that the average person is not prepared to deal with. And so it doesn't matter. If you pick a major, someone has done that and then gone to law school.
So last question is going to be for students that are currently in high school. What should what skills right now would you recommend, or what classes should they really focus on if this was something they want to look at in the future?
Sure. So if you do decide that you want to be one of those STEM attorneys, and I've got a very good friend who's in his last year of medical school who's now applying for law school because he doesn't want to be a practicing doctor. He wants to be a lawyer doctor who can help do both, right? Someone who can do medical advancement and then help turn it into laws and turn it into devices. So even if now you think you may want to end up in a STEM field, great, pursue that. You need that understanding, you need that background. For your average person that's not going to be in the intellectual property realm, not going to have a hard science, I recommend speech and debate. That's a great class. It's a skill set that will help you, because even if it's not just so much about getting up in front of a group of people and speaking, it teaches the preparation and it teaches argument formation. How to properly frame an argument is a skill, right? You don't go into the weight room and say, I want to be big and buff. I'm just going to start picking up weights and doing stuff. No, that machine works a certain way, right? There are certain ways you work certain muscles. There's a skill set to lifting weights. And if you don't have it, you're probably going to do a bad job lifting weights. The same thing is true with argument formation. You don't just show up one day making great arguments. It's a skill set. So my recommendation would be speech and debate, not only for the speaking element of it, but for learning how to research and how to form arguments. It's a good idea to be a good writer, in particular, if you want to be a lawyer. So much of law is writing. Good fundamentals. And I'm not the best example of this. My wife was an editor on our law review. She is the best with grammar and spelling and all that stuff. I'm not the best with that. And I wish I was better even now. Even after, 3 graduate degrees and trying, I'm not as good as I'd like to be. You can never be too good of a writer. So if you have to pick 2 courses, writing skills and speech and debate are the ones that will probably aid you the most in trying to go to law school.
Cool. All right. Thanks so much. That wraps up our time. Last, please. Thank you.
Thanks for having me.
Certainly appreciate it. Have a wonderful day. Thanks so much for joining us.
Thanks, you too. Bye.
We'll talk to you later.